Hello and welcome to this discussion of civil liberties and selective incorporation. I'll be honest with you, this could be done without this video, but stay with us if you want a more in-depth explanation, you want to clarify answers, or just if you want to hear my thoughts. Let's be honest, we haven't seen each other in a while, and a little bit more human connection definitely can't hurt. This corresponds with pages 233 to 238 in your textbook. So again, if you just want to continue to sit quietly, totally fine. Two resources that will be available to you while you're doing this. One, there's a worksheet that is available digitally. You can annotate it, fill it in. It'll match roughly the sequence that we're going through. Two, you can just do this right in your regular government notes. Feel free to, all the cues, all the prompts will be in your notes. Pause the video when you need to, either to think or respond to a prompt. Go back if you need to hear something again or see a definition. And at the end, there will be a check for understanding as well as a place to ask questions. Today we're going to be introducing the idea of civil liberties and look at how it became such a central part of our shared American political culture. To do that, we're going to define the term civil liberties, important to know what it is, review the framers' intentions, and then finally analyze the impact of the 14th Amendment on civil liberties through the Supreme Court strategy of selective incorporation. Civil liberties are something we talk about a lot without explicitly defining it. We've probably mentioned them without you knowing it, like two dozen times throughout the year. A big misconception that we should address right away is that civil liberties and civil rights are not the same thing. Civil liberties are freedoms you have that the government cannot take away. The ability to speak, the ability to secure in your person and your liberty, having a lawyer with you. Now, you'll notice I'm carefully avoiding saying the word right before all of those because that's what gets us into a lot of confusion. These terms are used interchangeably, but when we talk about being protected from the government cannot do something to you, we're talking about civil liberties. This goes all the way back to the distrust of Parliament and King George III that the framers and founders fought against in the Revolutionary War. But it does touch on something that we want to look at, which is the confusion between civil rights and civil liberty. Despite the terms often being used interchangeably, cases of government discrimination, like not allowing certain groups to vote, those are civil rights. This is when the government gives out a privilege and it should be expected to distribute it evenly. We really do want to categorize those separately from civil liberties. The second misconception that we have to address is that civil liberties are not unlimited. The government is constantly trying to balance safety and security and civil liberties. A great example of this is 9/11. There's a lot of debate, and people feel really different ways about what this balance is after something like a major terrorist attack. So the government passes the Patriot Act, which allows certain suspensions of things like privacy, and how much of that do we need in order to be secure? You'll hear everyone from Rand Paul to Bernie Sanders fighting the reauthorization of the Patriot Act, shouting that your rights have been violated. What they really mean is your civil liberties have been violated, and that is very much open to debate. On the other hand, when Nate Tinbite, our SMOB, advocates for redistributing money so that schools get the same amount of funding regardless of property taxes or socioeconomic status, that is fighting for your civil rights. Policies like stop and frisk, the police disproportionately stopping young men of color and searching them on very little pretense, is where we get the most tricky, because that is both a violation of civil rights. They're targeting people of color unequal to white people, and they're also violating those young men's Fifth Amendment rights. So you have both of those. And so let me know at the end of this if you have questions about where that line is and how exactly we're defining civil liberties. So like I mentioned, civil liberties are important to the framers when they're writing the Constitution. They put in all these protections against Congress. They can't suspend habeas corpus. They can't write bills of attainder or ex post facto laws. But it's the anti-federalists who really push for the inclusion of a Bill of Rights. Interestingly, and kind of thinking about being persuaded by evidence, this is a place where Madison changes his mind. He's originally a Federalist. He doesn't think we need a Bill of Rights, but he will not only support the Bill of Rights when it comes to the House of Representatives after the ratification of the Constitution, but he will write a great deal of the Bill of Rights. In planning for that limited government, Madison said, "A constitutional negative on the laws of the states seems equally necessary to secure individuals against encroachments." It's not a word I say a lot. Encroachments on their rights. And he says, "No state shall violate the equal rights of conscience." Take a moment, and I'm serious, take a moment, pause the video, to put that in your own words and think about what part of the government does Madison mean? What is he worried about here? Maybe I should do little dances while we pause. All right, you have Madison's intention in the back of your mind. Okay, let's look at what actually went into the Bill of Rights. The First Amendment, for example, says, "Congress shall make no law respecting the establishment of religion or the free exercise thereof or of speech," blah, 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 blah. We know this one. What part of the government does the First Amendment protect individuals from? Think again. Excuse me, thinky dance. Okay. The emphasis in the actual writing of the First Amendment is on Congress. That means federal government. So you have the situation in which Madison may have been worried about limiting all levels of government. The quotes we look at focus on the states, is what I wanted you to know before. But the Bill of Rights only focuses on protecting individuals from the actions of the federal government. That's going to have a major implication when we put this into practice. When the Supreme Court starts to weigh these civil liberties, after, of course, establishing judicial review in Marbury versus Madison, how are they going to do that? Are they allowed to protect individuals from actions done by all levels of government? The first big test comes in a case called Barron v Baltimore in 1833. Now, this is not one of our essential AP government cases. It's just the one that will help us illustrate this point. A wharf owner named John Barron, a wharf being like a place where you dock boats. Some of us have varying levels of expertise on that. He accuses the city of Baltimore of damaging his land when they shift some things around in a construction project, and he can't dock boats there anymore. The question, though, the constitutional question is, does the Fifth Amendment protection of his property apply to the city of Baltimore and the state of Maryland in the same way that it would apply to the federal government? This becomes a question of due process, which is something we talked about in our discussion of O.J. Simpson and his rights. The Fifth Amendment says that no person shall be deprived of property without due process of the law. It doesn't directly say anything about the federal government. However, the Supreme Court looked at the case in a strict constructionist or original intent perspective. They put the Fifth Amendment in the context of the whole Bill of Rights and what the framers were thinking when they wrote that whole document. What did the framers intend? Despite Madison's earlier sentiments, the agreement seems to be that the Bill of Rights was seen as an exclusive check on the federal government, particularly because of early clauses that we talked about, the First Amendment, Congress shall not. So the ruling was no. Individuals were not protected from state governments taking their property or violating anything in the Bill of Rights. A lot of states had their own protections, but the Bill of Rights did not protect people from state government. Fast forward about 30 years to post-Civil War Reconstruction amendments. After the 13th Amendment outlawed slavery, the 14th Amendment was passed to protect newly freed African Americans. Take a moment to read 3 of the most essential clauses of the 14th Amendment. We are going to focus on the second one. No state shall deprive any person of life, liberty, or property without due process of the law. But all 3 of these are going to be important at some point in the next couple weeks, so take a moment, put them all in your own words. All right, how does this compare with the due process clause of the Fifth Amendment? Pretty similar. The key is the addition of the word states. that they can now also not infringe on people's rights. Like other parts of the 14th Amendment, the goal of the clause is to put the same limitations on state governments, which the federal government at the time thought was the perpetuators of slavery, and we can talk about that in a separate conversation. But the same limitations on the state governments that the federal government is in theory already following. Due process is still a pretty vague clause, but at least federal government and state government both have to follow due process. Before we move on, I want you to take a moment to predict. How could the 14th Amendment help address the problem that John Barron faced in Barron v Baltimore 30 years before? Do you think having this 14th Amendment would have helped him with that case? Put your answer down before we move any further in our 14th Amendment interpretation. The next section of your notes you are going to answer with a reading. Take your time, then come back to the second part of this video to go over the answers, and we'll review some takeaways before you do your check for understanding. So again, also be a place to answer any questions you have at this point or after the reading. Reading and questions are both attached. The questions are in that note-taking document I mentioned. See you in a few minutes.